Ethical Perspectives on the News is produced by the Interreligious Council of Lynn County, which is solely responsible for its content. The views and opinions expressed on this program do not necessarily reflect those of the staff and management of KCRG TV9.
Good morning and welcome to Ethical Perspectives on the News. My name is Scott Samuelson and I'm a professor of philosophy at Kirkwood Community College on the Iowa City campus. A few years ago, a 17-year-old named Andre Lyle Jr. punched a guy and stole his $5 bag of marijuana outside of Lincoln High School in Des Moines. Andre was arrested. What sentence did this minor get for punching someone and stealing pot? 10 years in prison, a mandatory 7 before being eligible for parole. That case eventually led the Iowa Supreme Court in a 4-3 decision to keep judges from automatically subjecting juvenile offenders to mandatory minimum sentences for crimes such as murder, sex abuse, kidnapping, and theft without first considering the offender's background. Recently, a bill was considered in the Iowa Senate that would allow for judges to sentence juveniles guilty of first-degree murder to life without parole or life with the possibility of parole. The bill has stalled out, but big questions remain. What kind of sentences do juveniles deserve? When, if ever, should they be sentenced like adults? What's the purpose of our juvenile detention system? Retribution or rehabilitation? And is it working? We have a great panel on today to discuss these questions. To my left, Jerry Vander, a Lynn County attorney. Thanks for being on, Jerry.
Sure.
John Whiston, professor of law at the University of Iowa. John, thank you for being on.
Glad to be here.
And at the end, Al Willet, an attorney at Elderkin and Perney. Al, thank you for being on.
Thank you.
Well, gentlemen, maybe we can begin, Jerry, with you. Let's talk a little bit about what's the purpose of the juvenile justice system and how is it different from the adult system?
Well, that's a good place to start out at. And typically, in the juvenile justice system, the focus is more on the offender. That is, what sentence is the appropriate sentence that would provide for the rehabilitation of the offender. Typically, in our juvenile justice system, those who commit crimes under the age of 18 typically are treated in a juvenile justice system where the focus is what is the best interest of the child and what kind of sentence will provide for the rehabilitation of the offender. However, the state legislature quite some time ago fashioned a law that would provide that those offenders that are 16 years of age or older that commit certain kinds of violent offenses will start their process in the adult court, and those that are 16 or older that commit adult crimes will receive adult sentences. And of course, now we've seen some changes in that way of thinking that's come down from our Iowa Supreme Court, as you pointed out in the Lyle decision.
Mm-hmm. Yeah, well, so I guess I'm still trying to piece this together. So it seems like we have sort of almost 3 tiers then, right? Sort of people under the age of 16, 16 to 18, and then 18 and above. Can you speak to that a little bit for us?
Well, the presumption has always been that a child, that is someone under 18, is going to be handled in juvenile court, as Jerry explained. But there are certain offenses that we have decided, the legislature has decided, we've decided as a society, should be treated in adult court, treated as if the person were over 18. And so there are some offenses where the juvenile is age 14, 15, they could be waived into adult court. The other charges, the more serious charges over the age of 16, as Jerry points out, start in adult court. So I think what we're all talking about, particularly with the Lyle decision, are the people who are, quote, waived or charged in adult court and treated as an adult even though they're under 18.
Right. Well, and so Al, let's get you on this too. So, I mean, is that fair? Is it right to be charging a 16-year-old, a 17-year-old like an adult, or when would it be right and when would it be inappropriate?
Well, the one thing that that we have to the advantage of juveniles is there's when the county attorney's office wants to waive somebody up to adult court, we can initially fight that, if you will, in juvenile court by saying the juvenile shouldn't be waived up.
Right.
You know, once they get to adult court, you know, with the Lyle decision and things we've seen, juveniles still need to be treated as juveniles. They're not adults yet, especially mentally, especially personality-wise.
Yeah, well, let's maybe talk about that. Can someone speak to that a little bit? I mean, what's really the difference? I mean, because some people might be thinking 17, 19, 16, 20, what's the big difference? You're committing a crime. Isn't it all pretty much the same? What are the differences there?
Well, I think in some points it's shades of gray. You know, one of my old jokes is, you know, he's 17 going on 25, or he may be 17 going on 7.
Right.
Just because you're a certain age doesn't mean you've achieved that level of adulthood just because you're 1 year away from being an adult in the state of Iowa.
Right. Yeah,
I don't want to speak for all the other males on the panel, but adolescent males' brains don't work very well. I remember my son when he was 14, 15, and I kept complaining that he didn't seem to understand the concept of risk. You know, that he just wasn't able to predict the impact of his actions in many ways. And that's because the brain doesn't develop uniformly. The neuroscience, which is kind of the basis of the Lyle decision and the Graham and Miller decisions at the United States Supreme Court, have cited a lot of the neuroscience that indicates that their emotional brain at age 17 might be pretty much mature and well-wired, but their frontal lobes, the parts that govern their executive function, their choices, their socialization, their ability to project what they're doing on the rest of the world, that really doesn't fully mature until maybe they're 25.
Right. So what about, I mean, you know, in 2012, the Supreme Court, the National Supreme Court, banned mandatory life sentence, or life without parole sentences for juveniles, I believe, convicted of first-degree murder. Am I right about that? But I guess the question that I had was, in other words, they could still get life without parole. It just can't be mandatory for them to get that. But I guess some of these things lead me to wonder, well, should juveniles ever get life without parole? I mean, should a 16 or a 17-year-old ever get a life without parole sentence if they're making, you know, choices that are sort of just, you know, poorly wired brain choices?
I think that's the Miller case that you spoke of. And in the Miller case, what our United States Supreme Court said was that juveniles, that is those that are under the age of 18, commit murder, cannot be sentenced to life without parole unless they are first granted an individualized sentencing hearing before the sentencing court that takes into account the mitigating circumstances of youth, take into account certain factors like their age, their immaturity, the involvement that they had in the crime, and their prospects for rehabilitation and some other factors as well. So it's not that you can't sentence a juvenile to life without parole for a capital offense like murder. It's just that before you do that or come to that conclusion, in some cases, in some rare cases, it'll be appropriate, our courts are telling us, but before you arrive to that conclusion, you first have to give that juvenile an individualized sentencing hearing and take into account a number of factors that the court sets out in that decision.
Right, so there's some serious checks, but I mean, so how often does it happen that a juvenile gets sentenced to life without parole even having gone through these? I mean, maybe we haven't had much time to sort of to see how this all works.
Well, actually, Iowa has had a fair amount of experience of this in the last 3 years since the Miller decision. There was a whole backlog of people who had been convicted of first-degree murder and sentenced to life without parole, and so they started going back and resentencing those people.
Right.
And there are a fair number, you know, on the order of a half a dozen out of the 30 or 40 that were in the class that were resentenced to life without parole. Basically, the judge determined that no, this wasn't a product of some immaturity and some socialization and peer pressure, but a really heinous crime that the person was fully culpable for.
And so in those cases, Al, or to anyone, is that, do you think, an appropriate decision? If it is truly a heinous crime that is not subject to peer pressure or immaturity?
I'm sure my philosophy is that it's the very, very rare case where you would get me to agree that a juvenile should be given life without parole. It should be an individualized sentencing hearing, going to the aggravating and mitigating circumstances involving that juvenile. And keep in mind one thing: a life without parole sentence is a lot different than for a 15-year-old than it is for a 35 or a 45-year-old.
Right.
And I think in that situation it becomes more punitive. So I know that we three lawyers can probably all come up with cases that were very heinous, where we could point to that and say, well, there's a life without parole situation. But I just think with juveniles, it's in my mind, it's the absolute last alternative.
Right, and I mean, that seems to me a very reasonable perspective. And then I guess my question is, so do we have a system like the one you're describing that actually makes it the very rare exception when a juvenile gets this? I mean, it sounds like what you're saying, John, is that it's not necessarily the system that we have, that it happens actually not uncommonly.
I'm just thinking of reading decisions from the Iowa Court of Appeals about this. And so, I haven't been party to any of those sentencings.
Right.
I know one of the problems we have to recognize is that Iowa has an indeterminate sentencing structure. And so the judges here aren't traditionally used to taking into account all of these mitigating circumstances and aggravating circumstances. That if somebody's convicted of first-degree murder, life without parole. Easy. Well, it's not easy, but it's done.
Right.
And so I think we're learning as we go along.
Right.
I think the lawyers, I think the law enforcement and county attorneys are putting a lot of effort into figuring out how to do this, and the judiciary is going to need to do that too.
Right. Jerry, what?
I think it's important to note that for a juvenile to commit a first-degree murder offense, at least in the state of Iowa, is a very rare occurrence. And I think what our appellate courts, though, are telling our sentencing judges is that it's certainly appropriate under some circumstances to sentence a juvenile to life without the possibility of parole in certain circumstances. However, when it comes to juveniles that commit capital crimes, you cannot have a sentencing scheme that has a one-size-fits-all sort of philosophy. You owe it to the juvenile under our state constitution to take into account their individual circumstances and come up with a sentencing that best fits the needs of that child if there's any kind of prospect for rehabilitation. Sometimes there will be, and sometimes they won't. Sometimes you won't know that. I mean, I don't know who really feels like they're intelligent enough to predict someone's chances for rehabilitation once they enter the prison system. That's a huge X factor, and no one knows that X factor.
Well, maybe we can talk a little bit about then what role the legislature should be playing in this overall. I mean, it seems like the legislature's trying to consider what role it should be playing. I mean, do judges need some kind of guidelines from the legislature, or are those just going to hamstring judges in some ways and create more of a one-size or two-size-fits-all sort of situation?
I think it's helpful for the legislature to give guidance in terms of if this is the statute they want the courts to enforce, here are aggravating factors, here are mitigating factors. But it's not like counting them up and say, well, you've got 3 aggravating and 2 mitigating, so I'm going to give you a more severe sentence. It's really a very individualized approach, and it's often the quality of what you're looking at, not the quantity of what you're looking at. You may have a juvenile, I may have a juvenile for a client who's had a terrible childhood, but there may be some outstanding things about this juvenile that rise him or her up to the situation where I can make the argument that, life without parole is the worst result for this particular juvenile.
Right.
So I think the legislature has to give some guidance, but then it's going to be to the discretion of our district court judges imposing the sentence to interpret those.
Right.
And of course, eventually, as these district court cases make their way up on appeal, the Court of Appeals, the Supreme Court will give more guidance as to how the factors might be interpreted. So.
It's complicated because you started with the Lyle case, and our Supreme Court has said not only are first-degree murder, life without parole cases, sentences a violation of the Iowa Constitution, but also imposing the mandatory minimums.
Right.
And so oftentimes that's a 70% rule, so 70% of a 10-year sentence that would have to be served. The law school has recently got a grant, and we have a a lawyer, come in as a fellow at the law school, and he's doing some work on this, trying to work with defense lawyers all over the state. And what he told me this morning was that there are 138 of these cases that are backlogged, that people who committed offenses as juveniles sentenced to mandatory minimums, and they're just starting to work their way through the system. So there's going to be a lot of development here.
Right. Well, that's interesting to me too. But I still want to go back to this. I mean, you know, I get the sense, and you correct me if I'm wrong, that there's been over the past, I don't know what, 30, 40 years, a kind of rise in this minimum mandatory sentencing idea, not just for juveniles, but just across the board. And that from the perspective of the legislature, it seems like kind of a politically winning thing to look tough on crime in order to impose these sentences. But I always get the sense that it's not just juveniles, perhaps, who need a kind of more individualized approach, but more broadly speaking, it wouldn't be so bad to have a more kind of individualized approach, but maybe especially true with juveniles. I mean, should we just sort of get rid of this idea of minimum mandatory sentences for juveniles, period? And I mean, you were suggesting, Al, that the guidelines should be fairly loose.
The problem I have with mandatory minimum sentences is it takes discretion away from our trial judges.
Right.
And we pride ourselves in Iowa that this is a merit selection. Judges don't run for election. They don't put up commercials. They don't raise money to get appointed to the bench. We arguably appoint the best and the brightest. So if we're appointing the best and the brightest lawyers in our community to go to the bench, why are we taking discretion away from them and saying, okay, here's 70% sentences, here's mandatory minimums in these cases?
Right.
To me, it's a conflicting argument.
Right.
And so from my perspective as a defense lawyer, of course, which I'm biased, I'll be the first one to admit, I would like to see fewer and fewer mandatory minimums. And there are certainly crimes where you can make the valid argument, we need a mandatory minimum sentence here if the person's a repeat offender, for example, in certain areas of criminal law. But you're right that there was this rise in mandatory minimum sentences for legislators who wanted to be tough on crime, and for judges who, certain judges, more philosophically align themselves with, sort of law and order type philosophies. But I don't think it's a good thing to take discretion away from our judges who, we entrust to make these decisions for us.
Right. I mean, I was somewhat aware of these minimum mandatory sentences, but I was shocked myself when I was reading about the Lyle case. I mean, here you have a kid who punches someone and steals, just a minuscule amount of marijuana, and he gets a minimum mandatory sentence for this, and he's 17 years old. I mean, I was pretty shocked to hear that. I mean, that's the kind of thing I'm sure that happens all the time, and that all of a sudden now this kid has to spend 7 years before he's even eligible for parole, if not 10 years. That did seem kind of extreme to me.
Well, a couple of points that need to be made here, and in particular with respect to the Lyle case, I think the average person on the street would say, yeah, someone who assaults somebody and steals a bag of marijuana perhaps should not go to prison for 10 years with a mandatory minimum 7. But the Lyle case was very unique. Lyle was an individual out of Polk County. He was sentenced there for that crime, but it wasn't as though it was his first brush with the law.
Right.
Lyle was involved in the juvenile justice system since the age of 12, and the sentencing court noted that he had a long history, a track record of juvenile offenses, including assault offenses, violent offenses, and other robberies. And the thing about Lyle was, he used to commit his robberies while also taping them, and he would post them on the internet. So he wasn't really being sentenced for just one offense. He was being sentenced for his body of work that he had done in the justice system. But along the continuum, I mean, I think it's also is important to note that Iowa does not stand alone in having a scheme of mandatory minimum sentence that apply to juvenile offenders. Almost every state has some mandatory minimum sentencing scheme for juvenile offenders, but normally, like in Iowa, it's always been reserved for those that commit crimes of violence. We're not talking about other kinds of property crimes. And normally, judges do wield a lot of discretion. We want them to, we trust them to. That's why they wear the robe. And it's just really striking that fine balance. Who do you want to have sentencing discretion? Do you want sentencing schemes to come from our legislature that we vote into office? Do we want it to come from judges? Or do we want it to come from the parole board? And really that's where this debate's occurring.
And I take it the answer is all of the above at some level, but the question is, how, who should sort of have the larger role there? But are you suggesting it is appropriate to have elected officials to have a fair amount of power in saying, look, when someone does this kind of a crime, they really should get at least this much of a sentence?
Well, I think the legislature is that body that's always been the most responsive to the people they serve, and they're the ones that traditionally have defined what is a crime and what is an appropriate sentence for that crime. If they get it wrong, they've got to answer to their constituents. Parole boards and judges, to a lesser degree, also, they don't really have to account to the people. And so there was a time when there was kind of a get tough on crime sort of attitude that led to the imposition of certain mandatory minimum sentences. We talk about 70%. It used to be 85% at one time, and then the legislature ramped it down to 70%. But our state legislature has made very clear that they want a dangerous, violent offender or someone who commits a crime of violence to serve a certain amount of time before they're eligible for parole, because before that time, then the sentence essentially was being determined by the parole board. And the parole board, they answered to no one really. And I don't know that we want a system of justice that metes out sentencing that way.
Right. Well, let's talk about the parole board too, because that's another player in this that we haven't talked about too much. I mean, how should the parole board go about implementing the kinds of, well, I suppose in this case with people who have gotten life without parole sentences as juveniles, and now all of a sudden those sentences are being thrown back, I take it, into the system. Does the parole board have to make the decision now that someone has met some kind of ideal of rehabilitation, or?
Well, it's interesting that you should ask that, because at the legal clinic at the law school, we have a case in federal court against the parole board right now, saying that they hadn't in the past done an adequate job of essentially giving the applicants for parole an individualized assessment of their culpability and their maturity and their possibility of rehabilitation. Nationwide, legislatures actually have taken a strong role in this. In Nebraska and California, the legislature established statutes that said, parole board, this is the way we want you to look at this. This is the schema we want you to apply. Basically applying the principles from the Miller and Graham cases at the United States Supreme Court. I probably shouldn't say anything about the progress of our case against the parole board, but I'm optimistic that we're going to get a good result from them eventually.
So, but I guess more generally speaking, a question I have is, well, what should be done with those who have been given these life sentences without parole as juveniles now that that's been shown or to be ruled somehow unconstitutional?
I can speak to that in one sense. I have a client who probably close to 15 years ago was pled to a state charge of murder in the second degree as a juvenile, and was given 70% of 50 years. And now that the state Supreme Court has told us that those sentences are unconstitutional, we have filed on his behalf, myself and another attorney from Sioux City, have filed an application to correct illegal sentence. And so we're going to have a hearing in front of his sentencing judge later on this spring in central Iowa to discuss the fact, okay, now the state Supreme Court has taken this away. Let's look at this adult now with an individualized sentencing approach, and what is the appropriate sentence.
So it's a kind of redo, so to speak, that
A second cut.
Right.
Yes.
Yeah.
Which we can't really do with offenses that occur right now. Exactly what Jerry said. It's really hard to make an assessment of what the susceptibility of an 18-year-old is to rehabilitation. What's that person going to be look like in 5 to 7 years?
Right. Well, that's kind of interesting, but it seems like there must be a large number of such cases that are going to have to be re-examined then, right?
I think in the Lyle decision they noted that there was about 100 cases that were going to have to be resentenced because those juvenile offenders had been sentenced under the mandatory sentencing scheme that they found to be an unconstitutional procedure. And so if you've got 100 juveniles coming back to be resentenced, some may be decades later, I'm not sure that our Supreme Court thought through the practical effect of this decision, because now you've got 100 cases coming back for resentencing where the original sentencing judge may not even be on the bench any longer. And besides that, you've got some cases where perhaps the file no longer exists, or may be lost. And then you've got, in those cases where there is a victim, try and track down the victim. And they have to come back, or be given the chance to come back to give a victim impact statement, and then relive the crime all over again, and reopens old wounds. And it's an incredible burden on the justice system, and it re-victimized victims. And we're in the process, I think, of still complying with the Supreme Court's directive in the Lyle case and going through the process of resentencing some 100 juvenile offenders. But still, when you get right down to it, it's going to be a judgment call. Someone's going to have to make that judgment. And I think the legislature has recognized the courts need perhaps more discretion in those cases of juvenile offenders, and they've given them that. They changed the law in that respect a couple of years ago, but our Supreme Court has gone further than any other state Supreme Court in mandating that the courts not only consider other sentencing options, but give them these individualized sentencing hearings that they claim or they indicate
and you're
are
suggesting
required.
that it's kind of imprudent, you think, that the court made that decision?
Well, no other state Supreme Court has gone that far with the decisions that have come down from our United States Supreme Court, but they're making their decisions based upon the state constitution, which is certainly their right, and they have the authority to do that. But no other state Supreme Court has gone that far to mandate that individualized sentencing hearings be conducted for every juvenile that committed a crime that would require normally a mandatory sentence.
Did the court go too far?
I don't think it did go too far. Since we've been doing this case about the parole board, I've been talking to lawyers and law professors across the country, and you know, it's a thin slice of lawyers, probably all very much like Al, but they are very impressed with the work that the Iowa Supreme Court has done. I think actually this may be just one more indication of a change in our social philosophy about how and why we punish people, that for decades, since the war on drugs, maybe as far back as the 1960s, the emphasis has been on retribution. You know, eye for an eye, tooth for a tooth, that sort of thing. And only recently do you see people re-emphasizing the principle of rehabilitation. So the cases from the United States Supreme Court emphasized, quote, the rehabilitative ideal, that we're looking to get people out of prison. Most all of these people are going to return to society. And so you see some very influential people, even conservatives like the Koch brothers, putting their oar in the water about that.
Yeah, well, just a few seconds, but Al, you wanted to get in on this. We're almost out of time. But
well, obviously, I think the Iowa Supreme Court's taking the right approach. And, you know, the remedy is to send these cases back to district court to give individualized sentencings to these adults who were once juveniles so that they do get a fair and individualized sentencing hearing. And, you know, disagreeing with Jerry just slightly, I think there is language in the Lyle appeal where Chief Justice Cady said, we know that we're hoisting a burden on the district courts, but in essence, it was the right thing to do.
Right. Okay, well, I'm afraid we're out of time, but I'd like to thank you all for a really interesting discussion, and I'm hoping the discussion here is one that you all continue in your homes and communities. So thank you all again, and we will see you next time on Ethical Perspectives on the News.
Thank you.
Thanks, gentlemen.
Excellent. Thank you.
Excellent.